Good afternoon. My name is Jonathan Page. I am a business attorney and founder of InPrime Legal. Today we are going to discuss 3 steps for protecting and maintaining your intellectual property assets, your very valuable and tangible assets that you use to market your business and to differentiate the value your business provides in the marketplace. So let's get ready to rumble. Yes, that is a trademark slogan, and we'll talk about that in a second. And I am only using that for educational purposes. Okay? So let's really get started. Step number 1 is to inventory all of your intellectual property assets. And we'll go through what sort of assets those might be. Step number 2 is to determine the best method for safeguarding your assets. And step number 3 is to implement procedures or policies within your company to retain and maintain the value of your intellectual property assets. So let's get started with trademarks. But before we get into the specifics of trademarks, let's briefly kind of go over a typical market space. So here's the market space, right? And in the market space, you've got buyers. These are all the people who are purchasing your goods or purchasing your services. And typically, over time, there becomes a very defined market space. Maybe it's 300 million. And all these companies here are competing for market share. And say, this is your company, your business. And within your business, there's a lot going on. You've got marketing activities, the sort of things you're doing to let the marketplace know about your business, who you are, and what sort of products and services you provide. You've got sales activities once they show up to your door, converting them to a paying customer. Once they are a paying customer, you're going to have production. You've got to deliver on the promise you made in the marketplace for the product or service that you're delivering. And then you need people to do all of that. There's all this production activity going on in your business. But most people, these buyers out here, are not going to get a tour of the sausage factory. They're not going to see how sausage is made. They're just going to purchase the sausage. And so what you're doing, in addition to all of these activities, is to produce, right, a product or deliver a service. And hopefully, if you're trying to differentiate yourself from your competitors out there, right, because your buyers have lots of choices on where they're going to get that product or service, you're going to be focused on better quality, or you might be focused on providing a more affordable product. And by the way, those are the 2 most used ways to differentiate yourself in the marketplace. Not necessarily the best, just the most used, which is on cost and quality. But you might also be incorporating within your product or service unique buyer utility. Utility that other competitors aren't providing to buyers. For example, with our business, we provide legal services. And with a traditional law firm, you're going to think bill you by the minute. We decided to diverge from the traditional model altogether. So we promise predictable fee. We charge a predictable fee every month. We guarantee a 10 times return on investment. We are business first. That's how we approach every legal project that we do for our clients, is through a business first lens. We're actually business people who happen to be lawyers. Those are the value, the utility that we are promoting in the marketplace. And so then you get to how you communicate that in your marketplace. Again, people aren't taking a tour of that sausage factory. So what most businesses are going to do is they're going to use a word, for example, a brand name. Tiffany's, for example, was one that you might have read about. They're going to be using a symbol perhaps, or a design, or even a tagline, or many other things to communicate this value proposition, the value utility, the affordability, the quality, that's being produced by marketing, sales, production people, all the activities that are going on in your business. This is what we're talking about when we're looking at IP, intellectual property, in particular when we're looking at trademarks. So the first step was to inventory your IP assets. Typically, your IP assets are going to fall into 4 buckets. You're going to have trademarks, you'll have copyrights, patents, and then you'll have trade secrets. So, moving on to your trademarks. A famous word or brand I mentioned was Tiffany's, right? So when you think about Tiffany's, it identifies the origin of those goods or services. You think about jewelry. That's the products that they provide under the Tiffany's brand. But not only do you think about jewelry, you also think about specific things that are specific to Tiffany's. You think of luxury, fashion, superior workmanship. These are the value elements that they have, or components that they have incorporated in their product or service, that they're trying to bring underneath that brand name. That's why that brand name has so much value. And they're trying to use that brand name to identify the source of their goods as Tiffany's and not as any other competitor that might be out there in their market space. So what a trademark does is a trademark uses a word, a symbol, a design, a tagline to identify the origin of certain goods or services, and allows you to differentiate those goods or services. It allows you to teach a consumer, to educate a consumer on how to differentiate those goods or services from your competitors. So that's what a trademark is. A symbol, for example, could be that famous Nike swoosh that you see. That's a symbol, but when you see the Nike swoosh, you know that those shoes or that clothing item, the source of those goods are from Nike. It could be a design. A lot of trademarks are the way that you have designed that word or name. Could be the colors that you've used. The Tiffany's box, for example. When you purchase a Tiffany, you've got a turquoise box, or what's called a robin's blue, I believe is the name of the color. It's a very specific color, and when you see that colored box in that certain shape, you know that you're likely getting a Tiffany's ring. They've trademarked that color to make sure that nobody else in the market space can create confusion around the use of that color with that box. And then, of course, a tagline. We talked about one. We talked about a phrase, let's get ready to rumble. That actually is a trademark slogan. And those are other trademarks that you can use, that you can protect out there in the marketplace. So what do? Now that you know how to identify those trademarks, how do you protect them? Well, first and foremost, trademarks are a use it or lose it. So if you don't use it, then you will lose the rights to that trademark. Secondly, it's important to understand that it's not registration of the trademark that gives you rights in the trademark. It's the use of the trademark. As soon as you start using it, and as long as it's not somebody else's trademark out there, so it's unique, it's different from anything else out there with regards to your specific goods or services, then you're gaining trademark rights in it. So the first and foremost way to protect your trademark is to use it and continually use it. And with that, you also want to make sure that you're consistently using it. So oftentimes what businesses will do is get a style guide. They'll have a graphic designer create for them specific fonts and specific letters and sizes and designs. All of this will be put into a specific manual, style manual, for how to use their brand name or their symbol and so forth out in the marketplace. And this is something that you would give to your vendors who are using your trademark. Or you might give it to a graphic designer who's creating other iterations of products or uses for your trademark. Or it may just simply be for your employees to know how you need to use this when they're out there communicating your trademark in the marketplace. So consistently using that's going to be your first kind of method of protection. Then there's registration, and you've got federal registration and state registration. Federal registration is going to be done with the United States Patent and Trademark Office. Again, federal registration doesn't give you a trademark. What it does do is it gives you access to important benefits. So once you've registered it, then it is presumed that your trademark is valid and that you're the valid owner of the trademark. So there's a large hill that has to be climbed if somebody's going to challenge that. They've got to come and get over that initial presumption. But it also gives you access to additional remedies, statutory remedies, potentially attorney's fees, remedies that you wouldn't otherwise have access to because you registered it. And it also provides constructive notice. So one of the defenses is I didn't know. But as soon as it's been published, then everybody is constructively presumed to have knowledge that you were the owner of that trademark. State registration is not going to give you as Oh, and again, with federal registration, there's a key element here. In order to obtain federal registration, one of the key things you have to show is that you are impacting commerce in more than one state. So it's not sufficient to just be be in a market space that's just in Georgia, for example. You've got to be able to show that you have sold your products over state lines in other states, or that you are engaging customers in other states for the delivery of services, and there's other ways that you can show that you're impacting commerce over state lines, but that is a key element that you've got to show in order to get a federal registration. So now there's state registration. State registration, unlike federal registration, doesn't require you to show that you're impacting commerce across state lines, but it does require you to show that you're impacting commerce within that state. And just selling a good or a service is going to be enough to show that you're impacting commerce there. Now, the state registration also gives you access to statutory remedies, state remedies, potentially attorney's fees, depending on what state you're in. It's not going to be as broad a protection as the United States, because it's only going to protect you within that state. It's not going to be necessarily the same remedies. It just depends on what remedies the state legislature decided to provide, but it does give you some initial additional access to additional benefits. It's also a lot less expensive than federal registration. So state registration is another great way of protecting your trademarks. All right, so copyrights. And since we're about to talk about copyrights, I thought maybe I'd have a glass of water, because I'm particularly thirsty. Hopefully you can hear that.
Yo, VIP. Let's kick it.
Right? I do take dance lessons. Ice, ice, baby. Right, so Vanilla Ice. I'm sure you're familiar with them. Had a great song, made a lot of money. But what about David Bowie and Queen? They had Under Pressure. Wasn't that very similar? Absolutely. So there was a big lawsuit because David Bowie and Queen and the person who wrote that musical composition said, we had a copyright. A copyright is an original work of authorship. It's an original writing that you're the author of. And a copyright is granted to you under the United States Constitution. Unlike trademarks, it's actually something that's found under Article 1 of the U.S. Constitution, which grants the exclusive rights to an author of their original writings for a limited period of time. And so Vanilla Ice came out with this great song, and Queen and David Bowie said that was infringing on our copyright, on our musical composition, on our original work of authorship. There was a settlement, and apparently Vanilla Ice paid out a large sum of money, so they took this very seriously. So the question for you is, what sort of original works of authorship, what original writings do you have in your business that you want to protect? And understand that writings is given a broad definition. So jewelry, for example, can be a writing. Designs can be a writing. So there might be several places within your business that you might find this. One could be your business plans, your marketing plans. We are doing some construction, so if you hear some noise every once in a while, don't fret. That's what's going on. Business plans and marketing plans are all copyrightable if you were the original work author on that. Your marketing collateral. You might have a 4-step process for doing X, Y, and Z that sets you apart from your competitors. That 4-step process might be something that you want to copyright. Your computer code that you use to develop a piece of software can be something that you can copyright. So identifying all those unique things that are your original work, your writings, your original authorship, are things that you'll want to identify as part of inventorying your IP assets and determining, what you have. So how do you protect them? Well, first and foremost, you see this was my original work. I know you're very impressed. I protected it by putting a copyright symbol, InPrime Legal, and yes, a company can own a copyright. 2018, the year, these are the 3 main ingredients that you need. The copyright symbol, the name, or the author, and the year. And then, of course, a lot of people will put all rights reserved, which just means you reserve your rights to your copyright. In case somebody infringes, you're letting them know that you reserve your rights to go after them for infringement. So some key things with copyrights. Like trademarks, you don't have to register your copyright to have a copyright. The mere fact that you created something original that's within the definition of a writing gives you a copyright. So why would you register? Well, again, like trademarks, there's lots of benefits to registering. One, if you want to file a lawsuit against somebody for infringement, you're going to have to register your copyright. And there's specific time periods that you will need to do that in as well. So it's important to understand all those different time periods and what you can and cannot do. So when you're looking at your work, if there's particular material that's very, very that gives you a huge competitive advantage, that might be a reason to go ahead and register it for a copyright, because you're likely going to have thousands and thousands of items within your business that are all copyrighted material. So you got to pick and choose and figure out which ones really give you the most value and what might warrant you filing for a copyright. Okay, so patents. Patents are a new, unique, or a non-obvious invention that you've come up with. It's something very new that's not obvious, that's new out there in the marketplace. Those are patents. And you might want to patent a product or an invention. An example might be Dropbox, for example. Dropbox has a patent, it's one that we all use, has a patent on how to share and synchronize files and folders within a network. They were one of the first people to think of that, and they created a patent for it. Other famous patents include cereal. Yes, Kellogg's got a patent on the process for turning bread dough into flakes, and they were able to patent the cereal box. There's a lot of famous patents out there, so you might want to identify within your business those parts of your production, those things that are getting you better quality or making your product more affordable or providing unique buyer elements that might be patentable, and filing for a patent. Now, here's the thing about a patent. Again, it's also based on the United States Constitution, specifically Article 1. And in there, under the Constitution, it says for a limited period of time. So once you patent it, you're only going to be able to have the exclusive right to use that for a specific period of time. Like copyrights. Copyrights is typically the life of the author plus 70 years. With patents, it can range depending on whether it's a utility patent or a design patent. But it could be 20 years, it could be 15 years. It just depends on the type of patent that you've applied for. But once the expiration is on that, then other people can come in and use that patent. So the last thing I wanted to talk about was trade secrets. That's the last bucket of IP assets that you should inventory. I'm sure you're familiar with Coca-Cola. Coca-Cola's got a very famous recipe for their Coke product. Is that recipe something that you can patent? Yes. Did Coke patent it? No. And why didn't they patent it? Well, they had a very tough decision, because they knew if they had patented it, it would protect people from using that recipe for that period of time, but also understand that when you file for a patent, you are disclosing to the general public out there how you use that invention, how you create that invention. You're providing all the details of that invention for inspection by the general public. So they would have had to disclose their recipe. And once that period of time expired, then anybody out there could start using that recipe. Coke didn't want to do that. So instead of patenting the recipe, they made a business decision, to retain it as a trade secret. So that's why the famous Coca-Cola formula is now down in downtown Atlanta. It's in this huge vault where very few people, almost no people within the company have access to, and they have created a distribution mechanism or process or procedure in order to make sure that different people who are working on creating that Coke product and putting it out in the marketplace aren't going to have full access to the entire process, to the entire recipe. So those are trade secrets. So one thing that you want to ask yourself are, what trade secrets do you have in your business? What are things that give you a competitive advantage over other people within this marketplace? And is it something you really want to patent, or do you want to make the business decision instead to retain it as a trade secret? So what can you do to protect your trade secrets? Well, first, limit use. Limit use to those who absolutely need to use it. And second is segregate the process, or segment the process. So instead of giving one person full access to the entire process from A to Z, maybe give one person, B and C, give somebody else D and E, give somebody else F, and they kind of all work together and nobody really sees the big picture. So that's segmenting the process. Those are two really key importance, because a trade secret, its value is in its secrecy, right? It's keeping it secret that gets its value. Using security measures to make sure you do that. Some other things that you should do for sure is make your employees sign non-disclosure agreements. The non-disclosure agreement can be there in their employee handbook. It might be there in their employee agreement. But making sure that they all sign an agreement that they're not going to disclose your trade secrets or other proprietary and confidential information of the company. Making sure that your vendors that you're working with, if they're going to get access to trade secrets or confidential and proprietary information, making sure that they sign a non-disclosure agreement. This includes people who are working on your business plan or working on some of these marketing collaterals. If they're going to get access to secret information in the process of doing that, then they also need to sign non-disclosure agreements. This also might include strategic partners that you're getting into business with. And then another way that you can protect your trade secrets, as well as your copyrights and your trademarks and your patents, is what's called a work for hire provision. And making sure that all your employees have a work for hire provision within their contract. That means that any discoveries, any inventions they make, any improvements they make to your secret sauce, all of that is still owned by the company and not by those individual employees. You can also have those parties that are outside of your company, 1099 contractors or vendors or people you've hired to do specific projects. You can have them sign work for hire provisions as well to ensure that you actually own all of that intellectual property and you're not letting that intellectual property out in the marketplace. So to sum up with trade secrets, it's making sure that you keep it secret, that you don't let your secret sauce slip out there, because as soon as it slips out there, you may no longer have the right to use that. I mean, it's important to understand that with trade secret, the protection really isn't around the secret. The protection that you get is preventing people from misappropriating that secret. But if you voluntarily let it slip, or you're reckless and you let those secrets slip out in the marketplace, then that can destroy your exclusive rights to use that secret within your business. So, to sum up, we had a 3-step process. One is inventory your assets. You're looking at trademarks, copyrights, patents, and trade secrets. Determine the best method for safeguarding those assets. We discussed many ways of doing that, from registration to internal processes and procedures. And 3 is implementing procedures to retain the value of those intellectual processes. We touched on that a little bit, creating internal procedures that might segment the process so that not every employee is seeing the big picture, making sure that you have your employees sign non-disclosure agreements, that you have policies in place that say that people can't disclose your confidential or trade secret information, that you limit the use of that stuff to people who have a need to know and not everybody within the company. Lots of different procedures and policies that you can put into place to retain the value of your IP assets. Also creating a style guide just for your trademarks to make sure that it's consistently, not only that it's used, but it's used consistently in the manner and form that you want your trademark to be used. That's another method of retaining the value of those intellectual property assets. Until next time, my name is Jonathan Page. I am a founder and business attorney with InPrime Legal. It has been fun rumbling with you and doing a little dance to Ice Ice Baby. If you want more information like what we've showed today, please look under the description of this video and you'll see articles and links that you can go to. You can also go to our website, www.inprimelegal.com, click on resources, and there's all sorts of great information there as well.